All right, so good evening, everybody. That's Tuesday, and it is July 20th, and we're part of the Summer Speaker Series again this summer. And I'm very excited because Miss Angela Yee-Hamshaw from Masuch Law is joining us this evening. We have tons of talks happening throughout the entire summer, and if you're unaware of when they're happening, they're Tuesdays, Thursdays, and Fridays throughout the summer. And if you go onto our Facebook group, you will see that there are tons of different talks with different presenters, etc. So I encourage you to go check those out and see what events are happening. But I'm going to introduce you to Angela, and she's talking this evening about the danger of do-it-yourself wills, which I have looked online and it doesn't look that difficult. So I'm very excited to hear. I would totally mess it up though. So I'm really grateful that Angela's talking tonight. So I'm going to pass everything over to Angela, and we should be good to go.
Perfect. Thank you, Robin. I appreciate the opportunity to speak. So I'll tell you a little bit about myself. So I am born and raised in Calgary. I've got a lovely family of Lloyd, who you can partially see on screen here. And we've got two lovely kids and a lovely dog, and we live in South Calgary. And I work for the firm of Masuch Law, but I've been a lawyer for 22 years. And I've been specializing in wills and estates for pretty much that whole time. A good portion of my career was working for trust companies. And if you guys are not familiar with a trust company is the portion owned by the bank where the trust company can act as your executor. So if you don't have a good choice for someone that you want to pick to be the executor to look after your estate when you've passed away, then you can go to the trust company and you can name a professional executor to look after your estate when you've passed on. So my role when I was with the trust companies was for the people that wanted to name the trust company on their wills, they would get my service and I would help them plan out what their content of their will would be. And so these were generally very high net worth clients. And so, but I couldn't write the will myself, because that's a conflict of interest, being that I was working for the company that would be the executor. And so we would have to fire off this letter with all the instructions and all the content that we created off to a lawyer that the clients had chosen. And then I would review the wills coming back from the lawyer to make sure that there was no surprises for us as an executor. And so I got to review a lot of wills. So I did that for 7 years. I got to review wills that people created themselves. I got to review wills from small sole proprietor lawyers. I got to review wills from the big downtown firms. So I got to see very quickly how wills can go wrong. And often I thought, boy, this is a terrible will. I should tack it up on my wall. And I thought pretty soon I would actually have a full wall and call it the wall of shame. So these are lessons learned from looking at some of those wills over the years. Okay. Now, like I said before, I do want this to be interactive, so feel free to interrupt and ask questions. I will explain a little bit about what I plan to chat about, so we might hit some of those subject matters later on in a later part of the presentation. But for now, as a usual lawyer presentation, we have to put in that disclaimer saying that this is intended for educational purposes only, and it doesn't actually replace actual judgment based on your particular circumstances. Okay. So the overview of the presentation. So how can do-it-yourself wills go wrong? And there are a number of headings. We'll talk a little bit about just the very low-hanging fruit of how to make a will. And so what makes a will invalid versus valid. We're going to cover off executor appointments, what assets are part of the estate versus what assets are not part of the estate and why that's important. Interpretation, this is a big one as well, so we can talk about that. And then what a lot of people don't know is that the order in which you present the clauses in your will can change the interpretation. So if you put things in the wrong order, it changes the interpretation. Okay. We're going to talk a little bit about undue influence, coercion, and suspicious circumstances. We're going to talk about incomplete wills. Taxes are a big thing, and dealing with liquidity in the estate. So liquidity is just a fancy way of saying, do we have cash to cover the things we need to cover? Okay, and then complex situations. So starting off, the wills legislation is based on province. So each province has their own wills legislation. So in Alberta, our legislation is called the Wills and Succession Act, and it sets out what makes a valid will. Sorry, I just bumped my desk and it changed the slide with my knee. So that's talent. See, I told you I'm really good with technology. So in Alberta, in order to have a legally valid will, one of the main components is that the person writing the will has to have mental capacity. So a person who's got dementia, a person who is not of legal age, a person who is coerced, if they don't have the ability to have a sound mind to make their own decisions and understand what it is that they're signing, then the will can be challenged as being invalid. So one of the failures is if you're doing your own will, then you are not meeting that legal test. So what the duty of a lawyer is when they prepare a will for a client is that they meet with the client and they are actually assessing your mental capacity. There's a 4-part test that we go through where we're finding out if you understand what the document means, if you understand what it is that you own and what you owe, and you understand who would be the natural people that would generally benefit from your assets if you were to pass away. And then we look to see if you're under any sort of disease or disorder of the mind that would affect your ability to make decisions. So we're looking at those things and we're making notes to make sure that if anyone ever calls that will into question, that we've got notes, we've asked the questions, we can prove whether or not that person had mental capacity. So if you're preparing a will on your own, you're not going to be able to prove to anyone you had mental capacity, and the will can be challenged after your death. Okay, so the other low-hanging fruit that the legislation covers off is it just talks about the bare basics in terms of what makes a will legal. So the will has to be signed at the end of the document, and it has to be signed in the presence of 2 witnesses. And the witnesses cannot be beneficiaries in the will. So we've seen situations where I saw one actually where a pilot decided that he would write his own will. Maybe he was thinking, I'm off on a flight tonight. I don't have a will. Maybe I should put one together. And so he wrote his own will and he gave everything to his wife. And then he signed it and asked his wife to be the witness. And so that it doesn't necessarily invalidate the will, but what it does is it negates the wife's gift. So in the same instance that he gave everything to his wife by having her act as the witness, he took away everything that he gave her in the will. So there's things like that where if you don't know the rules, it's easy to get sidetracked and do the document wrong. So a will might not be valid because it doesn't meet those formalities that are set out in the legislation. Okay. Executor appointments. This is fun because when you appoint someone, there's a lot of things you don't know about the job of the executor. So let me give you a for instance. When you've appointed an executor and they don't happen to be an Alberta resident, if someone has passed away and their will has to be probated, and then I'm going to chat a little bit about what probate is, but if a will has to be probated, it's a court process. It's done by filing a bunch of forms with the court. The court will take a look at who the executor is. And if that executor is not resident in Alberta, they will say, we're not giving you what you want, what you're asking for, which is a court order saying that this will is the final will. We're not going to give it to you unless you get a bond. And so what's the purpose of the bond? Well, it's like when you have a cleaning lady and she comes into your house and she breaks that precious Ming vase that you have sitting on your fireplace mantle. And if she wasn't bonded, she would say to you, I'm sorry, I don't have any money. It sucks that I broke that, but I can't do anything about it. I have no money. So being bonded makes sure that there's a pot of money to make good on mistakes. So that's generally the idea of a bond, is that if the executor is out of province, the court will say, you know what, we can impose a court order on someone who's in Alberta, but if you don't live in Alberta, we can't impose that that court order on you. So we're going to make you issue a bond. So if you take off with the money, at least there's money to protect the beneficiaries. And so a lot of people just appoint a family member from a different province, not realizing that when it comes time to probate, sorry, I'm just going to admit Sandy here for a second. Okay, sorry for the interruption, guys. Hi, Sandy, are you joining us? Hi, Sandy, welcome, welcome, welcome. All right, so in terms of the bond, so you're thinking, well, what's the big deal? Well, it is a really big deal because getting a bond means going to an insurance company or surety company, and the executor has to fill out a form that discloses all of their assets so that the bonding company can find out if they feel good about issuing the bond to you and what kind of risk that you are. And so if they do issue the bond, then there's a premium that the estate has to pay, and it's usually in the thousands of dollars. So you didn't know you were forcing the estate to pay thousands of dollars to get a bond issued. And then worse, if you can't get the bond because the bonding company doesn't want to provide one to you, you can't even act as the executor. So when you appoint, so when you talk to a lawyer, hopefully they're able to suss it out and take a look at what your choice is and say, okay, are you sure you want that choice? Here's the way around it. These are the things that you have to consider. And even worse yet, when you have an executor that's not resident in Canada, you're going to introduce tax problems. Okay, so you could accidentally make your Canadian estate be taxable in a totally different country because your executor is not resident in Canada. So these are things that we look for when we chat with our clients about who to appoint as the executor. Okay. Now, I guess I'm talking about executors as if you guys know what an executor is. And so just a brief explanation. The executor is the person that you appoint or put in the will that is to carry out all the wishes that you outlined in the will, and to distribute the assets and settle the estate once you've passed on. Okay, so that's the executor. All right. I've seen wills where people just talk about who they're going to give you know, their assets to, the things that they own, but they totally neglect, they don't even realize they need to appoint an executor. So we've had documents where there's not even an executor appointed. Okay. And then the last thing is when you appoint executor, you can make some poor choices. So for instance, maybe you appoint someone who is really bad at managing money. You've appointed someone who's just way too busy to even spend a lot of time looking after your estate. So these are the sort of things that I talk to my clients about, saying, you know, is this a good choice? Let's chat about who you've chosen. Okay. And so when you don't know what a lawyer has seen from an experience standpoint, then you can't benefit from some of that experience, and you appoint who you appoint. Okay. So that's executors. Okay, this is a big one for me. A lot of people, when they prepare their own will, they think that their will can control and tell us what to do with all of their assets when they pass away. And that's not the case. The will only can distribute estate assets. Assets that don't form part of the estate will not be governed by the will whatsoever. So you're saying, Angela, what the heck are you talking about? So I always start with the premise that think of your estate as a big empty cardboard box, okay? And we're going to put a sticky label on it, the estate. And when someone passes away, the executor has to sort all of the things that you own. So will this item go into the box? Will this item not go into the box? Well, all the things that end up in the box are considered part of the estate. So those are estate assets. And all those goodies that are in the box, the will can tell us what to do with them. There's a bunch of goodies that didn't end up in the box. And so what happens is things like RSPs that have a beneficiary listed on it. Well, it'll go to your beneficiary that you've listed on your RSP. It will not be part of the will. Same with tax-free savings accounts if you have a beneficiary listed, or life insurance, and sometimes jointly owned assets. If you die and there's another owner still alive, then those assets go outside of your estate directly to that other individual. And so there could be no assets inside your estate. And I've seen lawyers do this. So a lot of lawyers do what I call dictation wills. And what a dictation will is, a client shows up at the lawyer's office and tells the lawyer what to write in their will, what the content is. And a lot of lawyers just take dictation. They don't ask questions. They don't get any information. And so I've actually seen, let's say for instance, husband and wife, they go to a lawyer, they get a will prepared. The husband says, you know what? I want 10 grand to go to my mom because since my dad died, I want to make sure there's 10 grand set aside for my mom so that she has enough since dad died. And then the rest can go to my wife. And the lawyer goes ahead and writes that into their wills, 10 grand to Joe's mom. And then the rest can go to Joe's wife if Joe dies. Well, when you actually look at the husband and wife's assets, well, husband has an RSP. It names the wife as the beneficiary. So that asset didn't go into the will. Husband has a tax-free savings account. It names the wife as the beneficiary. So the tax-free just goes to the wife. Same with the life insurance. And then everything else he owns jointly with his wife. His bank accounts are joint with her. His investments are joint. His house is joint. So when Joe dies, there's actually no assets inside his estates because all of the assets went outside of the estate directly to his wife. So how the heck do you grab 10 grand from an empty box to give it to the mom? Because guess who the new owner of all those assets are? Joe is dead now. And so Joe's wife owns all of those assets and they're not in the estate. And so she can say, you know what, I'm the new owner. I don't really like my mother-in-law. I never did. And I'm not going to give that 10,000 to her. Or she can choose to be a good person and say, you know what, I will pull 10 grand from my assets and give it to her because that's what Joe would have wanted. But she's not legally obligated to because it's just those assets just aren't part of the estate. So you can see a lot of lawyers go wrong preparing what I call dictation wills because they never bothered to ask the client, what do you own? Do you have beneficiary designations on some of those assets? Oh, that's not part of the will then. Those sort of things can really trip you up. And this is the biggest area that I find goes wrong because most clients think that the will cover all of your assets. Well, it can't. The will only covers estate assets. Okay. So interpretation issues. Okay, so the great thing, the good and bad thing about lawyers is they've prepared wills over years and they've introduced language in the wills. And sometimes people don't know how to interpret a particular word or a particular clause in light of the situation that's in front of them. So let me give you a really, really easy example. So if someone writes their own will and they says, all my money goes to my brother, okay? So what does that mean? Does that mean cash only? Does that mean bank accounts? Does it mean investments of stocks is also money? So what do you mean by money? And so when you can't interpret what it means, then there's going to be somebody trying to interpret it one way to their benefit, and there's going to be an opposing party that interprets it a completely different way in their favor. And so if they can't resolve the issue, that's when you go to court. And that's when you have court cases that determine, they look at the set of facts, the judge makes a determination, and then we as lawyers follow that case law, because if we ever use those words again, we know how a court is going to interpret those words. And so when we're preparing wills, we have all these clauses that we understand how they've been interpreted by the court. And so we use them knowing how they, what the meaning is. Whereas if you don't have that experience of understanding what clauses to use and what words to use, you could actually introduce interpretation issues. And so that's never a good thing. Here's another interpretation issue. You might leave everything to your children, and you have a wife that you met, you married, and she came along with 2 children, and they were really young when you met her. And so you've always thought of those 2 kids as your children. But when you actually think about it, those are actually your stepchildren. And so when you write your own will and say all to my children, what you don't realize is that the law says that children are people that are your children, the people, children that you've either conceived and are yours biologically, or they are children that you have adopted. Stepchildren are in neither of those categories. And so in order for the law to consider them to be children, you have to adopt your spouse's children. Or you have to specifically include them in the will, or put a paragraph in that says, when I talk about children, I'm including so-and-so and so-and-so. Or you actually specifically name them. So you can see how easy it is to actually introduce problems in the will when you don't understand how the law interprets certain words. Okay. Okay, clauses in the wrong order. I did mention this before. So I've seen lawyers do this. And so if lawyers are doing this wrong, then maybe there's some difficulty out there in understanding that the order makes sense. So in every will, there's a clause called the residue clause. That is the catch-all paragraph that says whatever wasn't required to pay off my debts, it all falls into this catch-all paragraph called the residue. And then I give the residue to my spouse, or I give the residue to my children. So the residue is written up as if it's a pie, and you can divide up the residue in different percentages or different amounts to different people. Well, the residue means anything that's left over. So I've actually seen clauses where the residue clause goes in, but then later on, after the residue clause, it says this and this item goes to this person, or this amount goes to such and such a person. Well, you've now just messed up your will, because remember, the residue catches everything. So there's nothing left after the residue clause. And so yet you've got a paragraph underneath it that distributes an item when it's already part of the residue. So you can see what that does is it causes someone who is a beneficiary under that residue clause to say, that's part of the residue, that's mine. And then you have someone that says, no, I'm the one that's supposed to get that Ming vase. And so it's not part of the residue. See, it says in the will, I get it. Well, no, the residue goes to me. And that clause is after the residue clause. So that's a really, I guess, simple example of how the wrong order of the clauses actually completely changes its interpretation. Okay. So I'm going to pause there and see if anybody has any questions. I don't have the ability to see the chat right now. So if you want to chat, we can unmute.
There's currently nothing in the chat.
Okay.
But if anybody has a question at this point in time, this is a great time to ask.
Sure. Sandy, it looks like you've unmuted. Any questions?
I missed the beginning on the bonding part, and I feel bad because I did have a question on it, but I'll ask you privately just in case I missed a whole bunch of it.
Okay.
But quick question for you.
Mm-hmm.
What supersedes what? If I say have a life insurance policy and my beneficiary is my husband,
Mm-hmm.
but I've left in my will, for whatever reason, I've said in there all life policies or something to so-and-so, what supersedes? Is it the policy or the will?
That's a really, really good question. So you're right. So you can use the will. So you know how if you want to change the beneficiary, you can go to the life insurance policy and say, hey, I want to change my beneficiary. And they'll say, hey, fill out this form. And so it's a form called a change in beneficiary designation form. So you could use that form to change the beneficiary. But you can also use your will in the same way. So if you wanted to change the beneficiary, you can say in your will. So this is a hard concept to understand because you're using the will to put a beneficiary in it, but the life insurance doesn't become part of the will. Okay, so if you've named a beneficiary, it goes to that beneficiary. That life insurance is not part of the estate.
Oh.
But so to answer your question, so it depends on which is the most current in time. So let me give you an example. So if you set up your life insurance 20 years ago and you named your brother to be the beneficiary, and then fast forward 10 years later, you get married and you say, oh, well, okay, I now have a husband. I want to name him the beneficiary of my life insurance policy. And so you create a will, and in your will, there's a paragraph that says, whatever designation I have in my life insurance, I want to change it and I want to make it my husband. So you can see that the will was more recent in time. So because the will is more recent, it overrides what you did with the life insurance company on what you've indicated, okay? But it also works in reverse. If you did a will 10 years ago, and then now, today, you go and you get a new life insurance policy, and you fill out the application form, and you indicate that the life insurance should be your daughter, then that life insurance designation is now newer than the will. So that would override what was in the will, okay?
Okay.
So this is a very, very tricky area, and we have to be very careful, because I have a lot of people who name their kids, like they'll say, okay, my spouse is the beneficiary of my life insurance, but if my spouse isn't around, then my second choice is for the life insurance to go to my 2-year-old and my 4-year-old, and then they think, you know what, I have a will. The will says that the kids won't get the money until they're age 25. Well, remember, you just named your 2 kids as beneficiaries on your life insurance. So you forced the life insurance to go directly to the kids and not into the will. You put all the clauses in your will about age 25. And so you have no ability to control the life insurance with all the clauses in the will. So did you follow?
Yeah, and that's my situation right now, as you're
Yeah.
saying it. It's the exact same thing. We have it in the will, but not the actual policies.
Yeah, because you
Okay.
named the kids. And so remember, the rule of thumb is if you've named a beneficiary on that policy, it doesn't go into the will. So the money goes to the kids. And so what happens? So then the money would be paid to a trustee. So that could be, let's say you pass away, Sandy. And so you said that life insurance goes to your teenage girls. Well, what the life insurance company will do is they won't pay the funds to a minor. So they'll pay it to a parent or guardian of those minors. And then if your kid is a smart kid, they'll say, you know what, you're only allowed to hold on to that money while I'm a minor. The minute I turn 18, I am no longer a minor. So give me my $500,000 in life insurance proceeds from my mom.
Oh,
right?
Okay.
So because you put all of the provisions about holding it till age 25 in your will, but you never had the life insurance proceeds paid into the will, into the estate. So none of that matters. So I don't know if I've lost you guys, but that's a big thing that I look for when I'm looking at your assets, and I structure the whole thing properly, because you're going to have a mismatch of instructions versus where the money actually goes.
Yeah. Thank you so much. That was very clear.
Yeah. Okay, good. Sometimes I'm like, am I saying that clearly? I don't know, but hopefully I am.
Clear as mud.
Okay, perfect. Okay, and then if there's time at the end, we'll talk about that bonding issue again for you, Sandy. Okay, so undue influence or coercion. So one of the things that I look for when I'm doing wills is, hey, do I have an elderly client? Do I have a 95-year-old client being brought in by their daughter? And the daughter's in on the meeting. And the daughter is telling me that, mom really wants to give everything to me because I've helped her take her to all of her doctor's appointments. And my brother is, my brother's never been reliable, and she just wants to. So do you see how that can be suspicious circumstances? You don't know if mom is vulnerable and if she is being forced by her daughter to create a document that gives everything to her. So when I'm faced with those circumstances, I let the daughter be in the room. But when it comes time to sign the document, I boot the daughter out of the room. And I talk to the client directly, and I find out if she understands what the document says. I find out the reason why she's cutting out her son out of the will. I find out if she's being forced to create this. So if you're doing your own will, there's no one there to be an advocate for that elderly parent, right? So if you force mom to write her own will, then you're influencing her or coercing her to do a will. And that's one of the things that is a benefit of going to a lawyer, is that they will suss out those suspicious circumstances. And so if brother ever comes in and says, wait a minute, I don't understand why I was written out of the will. If the lawyer took good notes, they'll say, you know what, mom thought that you had enough money. She had reason to believe that, you know, you got some money already when mom's sister died, and the daughter didn't get any of that money when so-and-so died. And so she wanted to make sure that so you can see how the lawyer digs in and finds out what the reasoning is that someone has done something that seems unnatural, which is cutting out a child out of their will to make sure that there's no suspicious circumstances. Okay, so that's one of the things that you can fall prey to when you're doing your own will, right? Or having someone do their own will. Okay. God forbid you have a brother or sister that sticks a document under mom or dad's nose and says, you know what, can you sign this? Right? So that's a do-it-yourselfer as well, where it can go wrong. Okay. Incomplete. So this is when, for instance, like we talked about, where there's no executor named, or there's things that you just don't think about. Like, you know what? A will allows you to name a guardian if you have minor children. So maybe the will doesn't even talk about a guardian. Maybe the will forgets to say that, oh, if the money is going to a 2-year-old and a 4-year-old, that shouldn't happen. The executor should actually manage that money until that 2-year-old is 25. Or that 4-year-old is 25. So maybe you totally forget to put in provisions in the will to say, hey, I shouldn't be giving money to, like, cut a check to a 2-year-old or a 4-year-old and let them manage the money, right? I've seen wills that don't have a residue clause. So you talk about, you know, giving the bank account to such and such a person and the house to this person, and then you think you've covered it all, but then you didn't realize actually you had this investment that isn't, because you don't have a residue clause, that investment, there's no clause in the will that covers what happens to that investment. Okay, so those are the sort of things that we look for to make sure that the will is complete. Okay, what else? Ooh, this is a good one. Taxes and liquidity. Yeah.
Sorry, it's Kathy.
Hi, Kathy.
So if you did forget something that wasn't listed in the will, what happens to it?
So normally we have what we call an intestacy. Well, I guess, is it called an intestacy? Yeah, no, it's an intestacy. So what is an intestacy? So when you have a will, you die testate. When you don't have a will, you die intestate. And so also you can also have an intestate when your will doesn't cover off everything. So there are laws in each province. In our province, it's the Wills and Succession Act that says, hey, if someone dies without a will, the legislation says this is who gets it. So what ends up happening is when you have a will that's not complete, those intestacy rules get brought into your will. So now you have a will that isn't complete, so you now need the legislation to complete that will for you. Okay, so it might end up going to someone you don't intend because the legislation just didn't match what your wishes were.
Okay.
Okay.
Thank you.
Okay. So taxes. So what a lot of people don't realize is that when you pass away, the income tax rules basically say we're going to pretend that the deceased sold all of their assets at its fair market value on the day that they died. They didn't actually sell them, but we're going to pretend that they did, and that's how we assess taxes. So for instance, if you have a house that you live in and it's your principal residence, if you sell it during your lifetime, there's no taxes on a principal residence. And so same goes on death. If you pass away and you have a principal residence, a deemed sale of your principal residence means there's no taxes there. But what hits most people is RSPs. So when you pass away, it's as if you pulled out all your money out of your RSP on the day that you died. You didn't actually pull it out, but that's how the law treats the RSP. So let's say, for instance, you've got 50,000 in your RSP. So in the year that you died, on top of your normal salary that would show on your income taxes, in your final tax return, not only do you have your salary on there, but now you have another $50,000 of income as if you earned that in a salary because your RSP was deemed to have been disposed of at the date of your death. Same with capital gains. So let me illustrate an example for you. So I actually had clients who came in And they had 3 real estate properties. They had their house that they lived in, and they had 2 rental properties. And they also had 3 adult children. So they came in to me and said, Angela, can you just write a will? The houses are of generally equal value. So we just want the house that we live in to go to child number 1. We want the rental number 1 to go to our second child. And we want rental number 2 to go to our third child. And so I said, so you want them to keep the property? You don't want us to be able to sell the property? Yeah, no, these properties have been in our family for a long time, and I want to make sure the kids have them. And so I said, okay, well, on your death, you're not going to have any taxes on the house that you live in, but you can only have no taxes on your principal residence. Now you have 2 rental properties. And if there's an increase in value in those properties since you bought it, then you're going to have capital gains. So let me give you an example. So let's say you bought that rental property for $100,000. And at the time of your death, that rental property is now worth $500,000. And remember, the rule is it's a pretend sale of that rental property when you died. So we have to pretend that you sold it at $500,000 on your death. Well, so what's the increase? Well, the increase was $400,000. That is the gain. But capital gain says you have to take half of that amount. So remember, the gain was $400,000. So half of that amount is $200,000. And that $200,000 shows up on your income taxes on the year that you die, as if you earned $200,000 in income. Okay, so what has that done? So we have now this couple that said, we have 3 properties and I won't let you sell the properties. So now we have taxes on the estate when both husband and wife die. How are we going to pay the taxes when we can't sell the very houses that have created that tax liability? So can you imagine if you did your own will and you just wrote your own will and said house number 1 to child 1, house number 2 to child 2, and house number 3, because that's what I want. Well, you didn't realize that, you know what? Some of those properties are going to have to be sold, because otherwise the kids don't have any money to pay for the taxes that arise from those rental properties. So when you didn't plan for it, now you've totally sabotaged the plan, because now we actually have to sell those houses in order to find money to pay for the capital gains. Okay, so that's an example of tax planning not taken into consideration because you've done your own will. Okay, and finally, my last one is, you know what, I'm not going to hit them all, but what I'm going to cover off is blended families and disabled beneficiaries. Okay, so blended families, I'm going to give you an example of a couple that came in. They had grabbed a will kit and they did their own wills. And the wife had 2 children from a previous relationship, and now this was her second marriage. The husband, this was his first marriage. He had never been married before, but he married this lady and he had no children. And they did wills where it basically says, we're going to leave everything to each other. So if husband dies, he leaves everything to wife. If wife dies, she leaves everything to husband. And then they said when they both die, they were leaving everything to her 2 kids. And they thought their wills were great. But their financial advisor said, you know what, I would really like for you to get your will done properly. And so they reluctantly came in and said, well, we have these wills already. We like what they say. And so can you just make it look legal by just preparing, hey, drafting monkey, can you just draft a will for us that looks just like what we already drafted? And I looked at her and I said, okay, so if you die first, wife, and you leave everything to husband, husband is not the father of your children. So what happens if he says, you know what, it's been 5 years since my wife died, and those kids never come around anymore. In fact, they don't even talk to me. I'm going to change my will. I can redo my will. I'm going to give everything to my sister. So the wife, so the problem with blended families is when people prepare wills, they think it's like a contract where you sign a will and you sign a will. And when we both die, it's going to go, you know, based on what our will says. But what they don't realize is all the assets flow to the surviving spouse, the surviving spouse can change their will as many times as they want after your death. And so where you thought that they were going to honor your wish, they completely sabotaged you and sent it to someone else. And when I said to the wife, so it's fine if your husband dies first, because all of his assets go to you. And when you die, your will give it to your 2 kids. That's fine. But what happens if you die first? Everything goes to your husband. Your husband now marries a new woman. And your husband and his new wife are going to do some will planning. How happy is his new wife going to be when that husband says, you know what, we're doing a will, but I have to make sure I give some of our assets to my dead wife's children. How happy is that new wife going to be? Okay, so we have different techniques to deal with blended families to make sure that the ownership of the assets does not pass to the spouse so that they can control the assets after your death. Okay, so that's the use of trusts and that kind of thing. Okay, and then the other complicated scenario is disabled beneficiaries. When you have a disabled beneficiary and you leave them in inheritance, what you might accidentally do is disqualify them for all their government supports. Okay, so if you have a disabled beneficiary and they're receiving AISH, which is the assured income for the severely handicapped, that beneficiary is subject to an asset test and an income test. And if they have too much money, the government says, yeah, no, we're not giving you any of those benefits anymore. And so even though they have an inheritance, they're losing their drug therapies, they're losing their medications, their dental, all of these things that the government support provides. And so you have to be very careful around disabled beneficiaries. And so we have techniques to make sure that we can give money to a disabled beneficiary to support them, but we don't put the money into their hands so that they own the money and it bumps them off of their government benefits. So these are the sort of scenarios that people don't realize we actually have to look for and make sure that you're not going to put your disabled beneficiary in a difficult position. Okay, so I've gone now 45 minutes and I want to open it up for questions if you guys have. This is your opportunity to chat a little bit with a lawyer who's not going to charge you for those questions.
Always a good time to ask questions, isn't it?
Mm-hmm.
I know. I have a question.
Sure.
So as somebody who has young children,
Mm-hmm.
what about situations where you don't necessarily have a very clear choice when it comes to who would raise them?
Oh,
Did you pass away?
yes,
I know this is like such a common question, but
this is a hard question. And
yeah.
and so what I sometimes look at is what are the age of the kids? Are they quite young? And is there going to be a family member that lives in a totally different jurisdiction? And is it going to be a complete upheaval of your child's life to move them? So let's say you've got, family in Quebec and it's your sister in Quebec. And so if the kids are quite young, maybe it's a good idea. Maybe it's okay to name your sister in Quebec to be the guardian, because the kids are likely going to be moving to Quebec so their sister can look after your kids. But when you have teenagers, are they really going to be quite pleased that their life is going to be uprooted from their friends, their school, everything that they're used to, and you're going to move them to a different jurisdiction to move your sister? So those are the sort of things that you should look at. Do you have family members? Is there someone you trust implicitly to look after your kids? If it's not a family member, is there a close friend? And so those are the sort of exercises that I have you go through to say, who can you think of, first of all, that you trust? And is this going to impact your children's lives going forward? Is it going to be very disruptive? Will they manage the funds for the kids in an appropriate fashion? Because this money is meant for your kids, not to fund their lifestyle. I mean, of course, they might need a bigger house or a bigger car. And so you may have some allowance for that, some of those funds to make sure that your sister isn't going to be out financially because she has to have a bigger house to accommodate your 3 children. But we want to make sure at the end of the day, your kids still have something. So these are the sort of things that we talk about. So I don't have an easy answer for you, Robin, but we're going to have to dig into. And sometimes husband says, no, 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 it's my sister that would be better. And then the wife says, no, 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 your sister is not a good choice. I want my brother to do it. So sometimes you have those fights as well. So we have to sort of work through those with our clients.
We have a sort of a situation where there's nobody that we really, it's either family that is older that we would feel, like it would be a burden. And then we have, grandparents who are really quite old and unable to care for them.
Yeah.
Or we have one sibling who lives in the United States who we would not feel comfortable with our children growing up there. So we actually have sort of the opposite, where we have a really hard time trying to make a decision based on the fact of not a lot of options.
Yeah, what I hear is it makes the most sense to go to those parents that are older and give them the option first to be the guardians. And sometimes when you have, let's say you have 3 children and the oldest has now reached age 18. Well, they now can be the guardian for their siblings as well. So we look at those scenarios as well, where one is already an adult and your 2 remaining kids are younger and they're still minors. So if they're at that cusp of turning into an adult, maybe it makes sense just to have the sibling act as the guardian for their 2 younger siblings. So I have to take a look at your situation and find out what your options are.
Fair enough.
Does that make sense?
Always. I know it's so unique to each family too, so it's really hard to go into it, but yeah.
Yeah, so I don't have a clear-cut answer for you because, I wish I had a magic guardian solution for you.
I know.
Yeah.
We actually went through a similar, Robin, when I worked at Bennett Jones, part of employment was you got a free will. And we had an issue where we were trying to almost micromanage our wills, because my husband's from Australia, so we had in it that his sister would be guardian, but she wasn't allowed to leave the country because I didn't want my parents to be left without grandkids. And she had told us that you have to trust who you're picking as a beneficiary. You can't micromanage to the level. I wanted them to go to university and and all this stuff, and she said that you have to kind of have that discussion and that trust with whoever you're doing, that no matter how much I want to control from the grave, that I couldn't.
Is that did Barb Kimmett do your wills for you?
Or
Lexi Wong?
Lexi Wong, I think. Well, it was a long time ago that she did it well. And Cheryl, actually, from McCarthy Tedrow back in the day.
Oh, Cheryl.
Can't remember her name.
I know
Shorter
who you're
lady.
The glasses, with glasses.
Yes, yeah, super nice lady. Yeah. Anyways, they had kind of sat me down because it ended up being like 100 pages. I wanted all this stuff, so it was pretty funny. So I did learn that the hard way.
Yeah. So that's the benefit when you have someone else, when you have a lawyer write your will, they've got some things that they've seen go wrong, so they can make sure that they're addressed in your will. When you just don't have the experience, you just go on what you know, and so there's a lot of stuff that you might not know you even need to address. So it's the whole thing of I don't know what I don't know. So how can you cover it off when you don't even know to ask?
Yeah.
Right.
I have a question about elderly parents. So I know I have a friend whose parents both passed away in the last 5 years, and they added, there are 2 siblings who were going to be the beneficiaries. And before their parents had really bad dementia, they all went to the bank and went down to the land titles and added themselves.
Oh,
parents.
No.
What kind of implications does this have?
I have a situation right now where one sibling did that. They went and made mom sign their title over to that one sibling, and the other siblings are what? So what happens when you do that is you've subverted the will. Because you've made it joint, that asset goes outside of the will. And so now that sibling gets that whole house or that bank account, and it's not part of the will, even though the will says it's divided amongst all the kids equally. That house just isn't part of the division. And so when you make things joint, you change the ownership and you can totally sabotage the whole estate plan.
Well, for this one, they added both siblings to the title. So
Okay.
it wasn't a problem there.
Okay.
Are
Okay.
there
So
tax implications?
yes, yes, because remember,
Parents die?
this is mom's principal residence, but when the two siblings got added on, the siblings have their own house. So now their name is on the title to a secondary house, and now
Yeah.
they're going to have capital gains issues.
And is the capital gain happening when the last parent dies?
The capital gains is
Or when the year they're added?
the year they're added, that's when they acquire it. It's when they sell it. So not when mom dies, because mom's deemed to have disposed only her portion when she dies. So she's fine because it's her principal residence. But if the sibling changes the title or they sell it, now they're going to have some tax implications. So a lot of people end up doing that so they can avoid probate. And I said I was going to talk about probate, but and so probate is a really dirty word, and there's in people's minds. And so let's talk about what probate is. So probate is a court process where you file a bunch of forms so that the court can verify that this is the final will. It has nothing to do with people fighting. Even the most standard of wills may have to be probated. And so why do you need it? Well, what it means is you've got, for instance, a bank or land titles that says this asset belonged to the deceased. And we have to get our directions from the person who owns it. Well, it's really hard to get directions from the person who owns it because they're dead. And, seances aside, it's really hard to talk to them. And so we have to rely on a document called a will. And the will sets out who the executor is. And that is the person who's the boss, who gets to tell the bank what to do with that asset or what to do with that house. But can you imagine if someone goes to the bank and presents a will to them and says that they're the executor, and the bank relies on that document, only to find out the next day they have another appointment and someone comes forward and says, no, I'm the executor. My will was done way later than that first document. And so the second executor that came forward said, well, where's the money for the deceased? And the bank says, we gave it to the first guy that came yesterday that told us that he was the executor. And we don't have the money anymore. And the second executor goes, well, that will was done in 1990. I have a will that was done in 2021. So my will superseded that will. And so banks can't tell just because you're bringing, but having said that, some people only do a will in 1990 and they don't do another one. So that could be the last will. So a bank can't tell just because you have a will being presented to you that is the final will and that's the one that they should listen to. And so they say, we're not going to rely on your authority until you probate the will. And once you probate the will, then you will get a court order from the court that says this is the final will. And now we as the bank feel good about talking to you. And so that's what probate is. And so why is it scary? Well, each province has different fees that the court charges to do all that paperwork, to issue that court order. In Alberta, our probate fees are very, very low. The range of fees is $35 to a high of $525. So we don't do anything to worry about probate because you're avoiding $500, right? Whereas in BC, their probate fees, whatever's inside the estate, they charge 1.4%. So imagine if you had $1 million house in Vancouver. Well, what's 1.4% of $1 million house? So you can see the court fees are really high. So in BC, they will do all sorts of things like making houses joint. So when mom dies, it doesn't go into her estate because there's a joint owner alive and that house will bypass mom's estate. So that's why they do stuff like that. But you have to be careful. When you're avoiding probate, you might fix one problem, but you might introduce 6 more. So when people ask me these questions, I take a look and we do a weighing of the pros and cons, and then we figure out which is the lesser of the 2 evils. And then we figure out which is the best way to go. Okay, so I don't know if that answered your question, but in the particular situation where the 2 siblings were added onto mom's title, yes, they avoided probate, which is fine, but they also then potentially brought themselves some tax problems. And what sometimes happens is when mom was alive, it could have brought her a lot of difficulty. So let's say mom put the 2 daughters onto the title. Daughter is involved in a car accident. She was at fault. and she hurt someone quite substantially. And now there's a lawsuit against the daughter. Well, if I'm an injured party and I am suing you for damages for how much you've injured me, am I going to look for all the assets that have your name on it? Yes. Well, guess what? Guess what title has your name on it? So now mom's house might potentially be subject to an award for an injury claim. So when you add new owners to your title or add new owners to things that you own, you add their baggage onto you as well. Another problem is mom wants to sell the house, but she's got 2 other co-owners on the house with her. And one of them is holding out saying, no, I won't let you sell the house. I want that house. So now mom can't sell it because she needs the signature of the 2 others to sell the house as well. So when you add owners, you add their baggage with you as well.
Okay, and just for information, or for my information, if a will goes into probate, does that mean all of the assets are seized, like the bank accounts and all that kind of stuff?
No, probate has nothing to do with seizing the assets. The bank freezes it because they don't know who the right person to talk to is. And if anything leaks out of the estate, they're going to be liable. So they freeze it until they find out who the right authority is. So it has nothing to do with probate.
But you have to wait until after probate.
That's right.
Okay, so yeah, because I'm just thinking if, you know, my dad passes away, my mom's still around, my mom passes away, everything is left to me and my sister, and we need to pay the taxes on the house, or we need to pay the utility bills or something.
Yes.
All of those accounts will be frozen and we will have to cover it until the will goes through probate, right?
So I've had some estates where I just say to the people, you know, everything's frozen. You don't have access to to mom and dad's funds until probate has happened. Can you float the estate? And then once you have access to their accounts, then you can reimburse yourself for those expenses. So that's one way to do it. The other way is sometimes we look at only making one account joint so that when mom passes away, you've got access to one account. Or we have some of the life insurance flow out. So there's strategies around that. Without messing up the whole will, we can carve away some of those assets to create some liquidity so that you don't have to float the estate. Does that make sense?
But you have to do that while you're writing the will to make that.
You don't have to do it while you're writing when I write a will for a client, I look at all those things and we have a strategy and we plan, and I look at the will and I also look at what they have to do outside of the will to make this happen. So I will send them off to the bank to make that particular bank account joint, but not the others, because that will totally sabotage the will. Right. So those sort of things. So for me, it's like a jigsaw puzzle. I look at what the client's goal is, and then I make the ownership and the beneficiary and the will and all of those things all line up so that their goal comes into fruition when something happens to them, and that there's no pieces where they didn't realize that would happen that way. Okay, so all the pieces are put together to make sure they all flow towards the goal.
Okay.
Does that make sense? I hope I explained it in a way that it made sense.
Yep.
Okay. Yeah. So that brings us to 8 o'clock. I will stay on if you have any questions. I'm going to address, Sandy, your question about bonding if you'd like. But if you have other questions, feel free to stay on, or my contact information I'll put on the screen right now. Sorry.
Cheryl James, that's her name. Cheryl James.
Cheryl James, that's right.
That just popped in.
Okay, so there's my contact information for everyone if they need it. But Sandy, so to your question, when it comes time to probate a will, the court will look at whether or not the executor is an Alberta resident. The court, if you have 10 co-executors and all 10 are acting, and you have 9 of them from BC, and the 10th one is in Alberta, the court says, oh, okay, we've got one guy that's an executor that is in Alberta, we don't need a bond. But if the only person acting is a non-Albertan, then they will ask you either go get a bond, or you beg the court to waive the bond.
Okay.
And if all the adult beneficiaries of the estate say, well, the bond is to protect us and we don't need it, we'll sign something saying we don't need the bond, then the court is more likely to say, Well, if they don't need protection, then why am I protecting them? And so the court is okay sometimes waiving the bond because everyone is signed off. Now, the problem is if you have any minor beneficiaries. And so some people will say, well, my kids are all adults. But I said, well, but you don't know if you're at your death, whether or not one of your adult daughter will die. And the adult daughter's portion now goes to the grandkids. And the grandkids are now beneficiaries of your will. Well, they're 2 and they're 4. And so you can't get all the beneficiaries to sign off because a 2-year-old and a 4-year-old cannot sign off on the consent to waive a bond. So now you're stuck with a bond. So we just avoid that whole issue by making sure you don't have someone who's the sole executor that does not have an Alberta address. Does that make sense, Sandy?
Yeah, absolutely. Because
Yeah.
I was thinking bonding from like the corporate side where we bond projects and stuff. So I was curious how that worked with it all. Because I have a lot of that with my husband being in Australia for a while there. Our beneficiary was family in Australia. So I'm glad we fixed it after that. And I'm glad we didn't pass away when that happened because that would have been a nightmare, it sounds like.
So this is how you apply for a bond. So you have to go to an insurance or a surety company, and then they will give you an application form as the executor, and you have to fill it out, and you have to tell them all of your assets and all of your liabilities, because they want to know what kind of financial risk you are as the executor. And so if they look at you and go, yeah, right, you've been bankrupt 6 times, there's no way I'm issuing this bond, then you can't even act as the executor because the court says we needed that bond to give you that court order, and you needed the court order to go to the bank because the bank's not going to talk to you until you have that court order. So you can see you didn't get the bond, you can't get the order, you can't go to the TD, you can't deal with the estate. So now you can't even do the job as the executor without the bond. Okay, so what happens if you do get the bond? Well, you get the bond and there's a premium that is charged to the estate.
And it's expensive.
It's expensive. And so now you could have avoided that expense by having a better thought process around who you wanted to appoint as the executor. So I had clients today that said, we want to name, our kids are young, and so I want to name my brother who's in Manitoba to be the sole executor. I said, no, you're going to have a bonding issue and the kids are too young to waive the bond. So I said, can you find a family friend that's in Alberta, and we'll make that Alberta person and your brother act as co-executors.
Okay.
And then that will alleviate the requirement for a bond. So these are the strategies that I use when I take a look at what you've chosen for instructions for me.
Well, we're changing our will too because my one daughter is turning 18 next week. So we would like her to kind of take over a little bit with that, obviously with guidance of whatever, but when it comes to like guardianship, I think we're going to change everything. So that's why you're so good at explaining everything. I love it. I don't feel like I'm a deer in a headlight.
and I'm a little bit intimidated, Sandy, because you're telling me that you've had a will done by Lexi Wong and you've had a will done by Cheryl James. These are best names of really excellent wills lawyers. And I'm sitting there thinking, how am I going to compare?
Well, I was in my 20s. I didn't know any better.
Yeah. So the way that I deal with clients is I don't do the dictation will. I sit down with you and I draw pictures for you and I educate you and I say, look at your assets. Did you know that this flows through your estate, but this doesn't? And so I draw a picture for you and you walk away and you might decide that, no, you don't want to do it that way. So now you have a whole picture and in deciding how to fix things to make sure that everything flows the way that you want. And so I spend about an hour and a half in my first meeting and I educate you. So probably for a good 30 minutes, I'm explaining things and educating, so much like I'm explaining to you guys now. And then that way you can actually make decisions and we're all working off the same page. I don't say, hey, Kathy, come in, just tell me what you want and just like a list, blah, 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 blah. Just put this in the will, blah, 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 blah. Okay, off you go, right? So I don't do dictation wills.
Okay.
Okay.
That's great. That's because, a lot of people, and I even have clients that they go to the registry, they buy their little will package and they enter their name and, and then it spits out their will. And I'll be honest, I was even considering doing that to upgrade it. And that's why there's so much to it. It's holy smokers.
I know, that's what I fight against because It's like do-it-yourself dentistry. I always think, you know, you
Yes,
you have a pair of pliers. Why do you have a dentist, right? But it's the same idea where I fight. Like I got in an argument on Facebook because someone had suggested my name for someone who was looking for a will, and then all these people jumped in, these paralegals that jumped in, said, I've done wills for law firms, and it's just a template. You just switch out the name. And they didn't understand that they do the dictation wills. Like the example that I had where the husband said, give $10,000 to mom, but no one bothered to check to see that the husband actually, when he died, and if the wife survived, nothing would flow through his estate. So you wrote 10 grand in your will, but there wasn't 10 grand to give in the estate. And so those paralegals are the ones just drafting those, saying, oh, it's just a template. I'll just write in 10 grand to your mom and it's good. And I look at it and go, that's a lovely piece of fiction that you just wrote. But that's not going to work. Your mom ain't getting 10 grand unless unless her daughter-in-law has a kind heart.
Yeah. I like that analogy on the dentist with the pliers. I'm going to use that with accounting and bookkeeping, I think.
Yeah. So there's so many things that you don't know, you need to know. I had clients say, we were going to do our own will, but we thought we'd come see you. And then after their education with me, they're like, oh, we didn't realize all these things that we didn't know and didn't consider. Yeah. And then we're going to talk to our friends because they're thinking of doing their own as well. And you should talk to someone because there's also laws. So in those blended families, I've had clients go, oh, well, I'll do a will and I'll give it to my children. I'm not going to give everything to my spouse because he's my second husband and he's not the father of my children. So I'm going to make a will and I'm just going to give it to my kids. Well, what people don't realize is there's a piece of legislation that says your spouse is a dependent. And if you don't leave enough for their care and support, and they don't have enough and they have to be on government support, the laws allow that husband to make a claim against your estate. So if you didn't know that, then you would have written that will. And then after you died, the husband would have been armed with a right that he would have been made aware of, and he could have made a claim against the estate and unraveled that whole will. So
go ahead, sorry.
These are the things that I bring up to clients to say, hey, you're giving all to your kids, but did you know your husband's a dependent? And there's these laws that arm him with a bullet and he can load the gun and pierce your will with that bullet. And then, so how do we mitigate that? So these are the things that I talk to clients about. Like, so if you write your own will, did you know that? Right?
God, no, not even close. Is it the same if you're like, you have 3 children and let's say you have less than desirable relationship with one and you're like disowning one child. So you put in your will, this to this child, that to that child, and nothing to this child. Is that even legal?
It depends. Okay. So if you cut out that kid and that kid is an adult and that kid is not between the ages of 18 and 22 going to school, if that kid is not disabled, then yes. If you have a fully functioning, able to support themselves over the age of 21 kid, you can write that kid out of your will.
Okay.
So, but imagine a scenario where you have a kid that has a drug addiction and he has stolen from you and he has damaged every relationship because of that drug addiction. And so you say, you think of it as poor lifestyle choices. So you decide that you're going to write your kid out of the will and give it to the other 2 kids. And the problem is the law now looks at addiction as a disease. And so now that kid may actually be deemed to have a disability that causes him or her not to be able to earn a livelihood because of that disease. And so now you've written that kid out of your will, but he has no supports now. And so the government, the law says he's a dependent. You've written a dependent out of your will. He has a crack. He can make a claim against your estate. Doesn't mean he'll be successful. So remember, the claim, the person has to voluntarily bring the claim. And then just because they bring the claim doesn't mean they'll be successful. The court has to determine if they're going to be successful. But they're armed with the right to even talk to the court. So these are the things that we look for to make sure did you know that if you write out that kid that has a drug addiction, this might come back to bite you, right?
So does the kid who has the drug addiction, do they have to have a lawyer in order to contest the will? Like, is it going to cost them anything?
Yes, because when the mom dies, the law mandates that the executor has to serve anyone who could be a dependent with understanding that they may have a claim against the estate, and if they if they do have a claim against the estate, they must hire their own lawyer to make a claim against that estate.
Okay.
So the executor can't get probate if they don't follow the rules in serving that notice to that kid.
It sounds like it's a really big deal to be an executor of a will. So if somebody approaches me, I feel like I should say no.
It's a huge deal. I've had people who are very gung-ho in the beginning, and then after they're done settling the estate, most of them, the best I can achieve is just a neutral review of what it was like to be. That's the best case scenario, right? But most of the time they say, if I had known, I never would have agreed to it.
Yeah. Okay.
So I have a really quick question though. Actually, I don't know if it's a quick question or not. That's actually a lie. So it's an interesting circumstances, but I do know of individuals who have basically said, look, we're not going to do the will. We're not going to set anything aside when we die. Just put us in a pine box at the side of the road. We're going to let the government deal with it. You don't have to worry anything. But if they're family, there is a responsibility if there's leftover debt to the government and so on, like that can fall back on family, can it not?
No.
Okay.
So remember, let's say you sign if you have a visa, that contract is between you and Visa. And so if you decide that you're going to rack up your visa and you owe 20 grand on your visa and you go and die, your spouse is actually not responsible because that contract is between you and Visa.
Right. But taxes and government debt, that kind of stuff
is owed from the deceased.
Okay.
Yeah.
So if there's nothing, if they have nothing to give, there's nothing to go after anybody else in regards to that.
Yeah, that's right. So normally, when someone comes to me and says, my brother died and I'm the executor of the estate, and they actually had a will. The deceased brother had a will. And I look at it and we talk about it, and it turns out he has more debt than assets. I look at the sister and I say, if you're the executor, walk away. Don't do the job. Why are you administering an estate where there's no assets? Just let the creditors come. Because if no one looks after that estate and the executor bows out, then a creditor will actually apply to be the executor so that they can try to salvage what they can and maybe get 40 cents to their dollar.
Oh, okay.
Yeah.
Okay. Because that's kind of, it's like there's that looming potentially in and around us. And so it's always like, oh man, I really hope there's no ties that we have to end up having to, tie up on behalf of somebody who really has no plans or nothing in place.
I've had situations where a husband has gotten into trouble and the wife has no legal obligation to cover her husband's debts, but a lot of times we'll find a wife or a husband that feels a moral obligation to do so, and they cover it anyway. So there's a difference between a moral obligation and a legal obligation, right?
Fair.
And so we've had the only time that you actually transfer liability onto yourself is when you're the executor and you go and distribute the funds of the deceased to the beneficiaries and you have not covered off all the debts. Then you've let all the horses out of the barn and you can't get the money back from the beneficiaries. Now the liability transfers onto you because you as an executor had to have covered off the debts first before you went and gave away what was left to the beneficiaries. So if you put the cart before the horse, you transfer the liability, especially tax liability, from the deceased onto yourself. And that's where we advise our executors not to do distributions until you get your tax clearance certificate from the government.
God.
Okay.
That's good to know.
Yeah. So does anybody else have any questions for Angela? You got about 10 minutes left.
I have a question actually. There's what's it called? Sorry, I can't think of the right name of the document. It's a document where you're saying that I want somebody to be my not executor, but
Yeah, I know what you're
power
saying.
of attorney. Power of attorney.
Yeah, so outside of the will, there are two other documents that I help people prepare. One is called an enduring power of attorney, and the second one is called a personal directive. And both those documents look after you when you're alive, but you're not mentally competent. One is to allow you to pick someone to make financial decisions for you. The other document is to allow you to pick someone who will make medical, healthcare, and personal decisions for you. Okay, so the enduring power of attorney is the financial one. The personal directive is the medical health personal one.
Okay, so is it a good idea to have those prepared around the same time you're getting your will prepared?
I make people do it. If they don't already have one in place, I go, we're doing your will. Should we be doing your enduring power of attorney and your personal directive as well? Because these three documents cover off death and disability, right? Because if you are fine and capable, you don't need a document to govern your life. You just make decisions and you carry on with your life. But if you're mentally incompetent, then you need someone to make financial decisions, you need someone to make healthcare decisions, and then if you die, you need an executor to handle your estate. So those three documents cover off all of your, I can't do it myself because I'm not here or I'm not mentally here.
Okay.
Yeah.
Good question.
Awesome questions, everybody.
Yeah.
Yeah.
Thank you.
So Angela, I just want to say thank you so much again for talking tonight. It was really great and loved your presentation. And like I said, we're gonna it's recorded, so we're gonna stop the recording soon, and it's gonna go up onto the Lymph Balance YouTube channel. And so if anybody wants to go listen to it and go, I remember Angela gave this brilliant piece of like golden advice, and I can't remember those three words.
I didn't give advice, remember? Because I
No,
don't
sorry,
give
not
situation,
advice,
just
education.
information.
That was a good
Educational
lawyer
information.
comment.
See? You always need to have a good Angela around. So yes, so if you guys have any questions or whatever, please do reach out directly to Angela. Or if you want to go and listen to this again, it's available on the YouTube channel. So thanks again, Angela.
Great, perfect. Thank you guys. Thanks for attending.
Awesome. Thank you so much, Angela.
Thanks, Robin, for letting me talk.
Of course, thank you.